Okay, so I'm going to get started because we have quite a lot of ground to cover, and usually it takes a few minutes for everyone else to trickle in, but that's fine. I wanted to thank all of you for joining our webinar here today. On behalf of Gowling WLG, let me welcome you to this really exciting session called How Do Open Source Licenses Affect Your Intellectual Property Rights? My name is Usman Sheikh. I'm the head of our blockchain and smart contract group at the firm. By way of a little bit of background, our group has really been immersed in blockchain matters for probably about 4 to 5 years now. We have probably around 30 to 40 practitioners who practice in this space from all different sectors, whether it's IP lawyers like Rock Ripley or capital markets experts like Fiona, privacy lawyers, litigators, and many others. We represent some of the co-founders of Ethereum. We represent banks, stock exchanges, crypto platforms, pioneers, startups, many different parties in this space. And our group has really taken it upon itself to do quite a lot of speaking around the world to help educate governments and regulators. And so whether it's really addressing the member states of the IMF or the Monetary Authority of Singapore or assisting our local regulators, we've been very active in this space. If you would like to learn more about our blockchain group or our broader tech group, feel free to visit our website or feel free to reach out to any of the members here that you see on the screen today. Our contact is also in the invite. Before diving into today's topic, I should note that this particular webinar that you're attending today is actually the 5th in a 6-part series of webinars on some of the hottest topics that we've seen in the blockchain space. The first session was on crypto asset trading platforms. The second was on non-fungible tokens, or what are called NFTs. The third session was on stablecoins and CBDCs, or what are called central bank digital currencies. We just had one very recently on DeFi, or what's called decentralized finance. Today's session, as you know, is on open source and intellectual property rights. We have another session coming up. It's on October 14th. Last but certainly not least is a session on blockchain litigation, where we're really going to be covering a lot of the key civil, criminal, and regulatory cases that we've been seeing in the area. So to sign up for these webinars, just click on the invite that you received. There's a little bar that you can click on to sign up. You can also send us an email through our webpage. And you can also actually access all of these webinars online. And if you're having any difficulty, feel free to reach out to us. Okay, just a few other quick preliminary things before diving into the substance of today's session. I should note that this program is eligible for up to 1 hour of substantive CPD credits with the Law Society of Ontario, Law Society of British Columbia, and in Quebec. And you may also be eligible for 1 hour of CPD CLE credits in other jurisdictions. And finally, being lawyers, here is a key disclaimer, which is that this presentation is not intended as legal advice. For specific legal advice on issues that are going to be discussed today, please contact legal counsel. Okay, so with all of that background stuff out of the way, let's get into the topic itself. To that end, let me begin by making a few introductions. I'm very much honored to be joined here for today's session on open source and IP rights by our panelists. Let me begin perhaps with my colleagues. We have Rock Ripley. He is a partner in our Vancouver office and the head of our Vancouver office's Department on Intellectual Property. I actually work quite closely with Rock on many IP matters in the blockchain and tech space. We also have Fiona Duncan. She is a partner in our Waterloo office, and in fact is the co-chair of our global tech sector group. Her practice is primarily transactional with an emphasis on helping Canadian, US, and international clients with M&As and debt and equity financings. We also are very privileged today to have an external guest who we're thrilled to have with us. We welcome Leslie Mulvary. Leslie, I'm pretty sure I pronounced that correct.
Yes.
Great. She is Senior IP Counsel for SAP, one of the largest enterprise software companies in the world, in the company's Palo Alto office in California. She practices IP law focused on internet copyright and open source issues, and has worked extensively in matters involving international protection of IP in the computer software area, including working quite closely with development teams on open source licensing matters. Well, Leslie, welcome. It's a privilege to have you.
Thank you. It's good to be here.
So let's jump into the heart of the matter. Rock, if I can perhaps start off with you, but others feel free to chime in. What is open source? And if you don't mind, while our discussion is quite general today and not specifically focused on blockchain, can you also just tell us, why do we see open source really coming up quite frequently in the blockchain space in particular?
Sure, I'd be happy to. If we could advance right to this slide. So again, Usman mentioned being lawyers. Let's start with the definition. The most common definition of what open source software is one that's promulgated by the Open Source Initiative. Without delving too deeply into legal language, open source software is basically software that you, or more particularly your employees or contractors, can download off the internet and use in your business, subject to the terms and conditions, the open source license that's published with the software and that governs how you're allowed to use it. So in the open source context, these terms and conditions usually include the requirement that the open source code be freely redistributed, not necessarily freely in the sense that you can't charge anything for the redistribution, but in the sense that you can't legally tie someone's hands with respect to the redistribution, a making available of source code, and a requirement to permit modification or the creation of what are typically referred to as derivative works. With all that being said, there are, I'll say, countless open source licenses. So you always have to be careful to read the terms of the particular license you may be agreeing to. In terms of blockchain in particular, I mean, blockchain, of course, the nature of blockchain is that it is a distributed ledger. It's not centralized. So when you're mining Bitcoin, when you're adding new blocks to a more general blockchain, all that computational activity is being done by different people independently. And one of the things about open source licenses is that these requirements I just talked to, for example, the requirement to make your source code available, a lot of times, not always, but a lot of times, those requirements kick in when you distribute or redistribute the software. So in blockchain, when you're taking software and you have to, by definition, distribute it to a whole bunch of different people who are running their own nodes, that act of distribution will trigger a lot of the requirements that you find in the open source licenses.
Well, that's really interesting. You talked about downloading this software. So why would a company use open source? And you mentioned licenses. What type of licenses are out there?
So the reason to use open source, I mean, there are a few. The one that's most common is that you don't need to reinvent the wheel. If someone has created a great product, they've made it available online, and you can download it with what hopefully are reasonable terms, and you can use it commercially in your business, why not do it and focus on the part of your business that is going to generate value, your proprietary code that is going to generate a lot of revenue for you. That's the inbound answer. Inbound being you take open source software from the internet and you download it to your own computer or business. In the context of blockchain in particular, where there is a very strong open source community and there's a very strong emphasis on security, I think it's also important to talk about outbound licensing. So the software you create in-house and that you want to share with the open source community, it can be important for credibility. For security, it can be important because you want other people to be able to analyze your code and to make sure that it, in fact, mathematically is as secure as you say it is, which can help increase adoption. So the slide says right here, that can also help drive competition in the market, which can be very good. Your business model as well may not necessarily be to keep the source code proprietary and to make money by selling the code. It may be you want to get as many people as possible using your code, and then you have a services model where you offer services to support that code. So by making your code publicly available and licensing it outbound, you can increase revenue that way. It just might be a different type of revenue than a software company might be traditionally used to.
So maybe before, we'll just pause there before going into the type of licenses. Leslie, maybe you want to speak to some trends that you've seen and on this topic as well.
Sure, and yeah, there's a slide. So this is actually a slide that one of my colleagues at SAP put together for some of our internal training. And this data is, it doesn't have a date on it, but I think it's from 2019 because I just looked yesterday and there are now over 128 million repositories on GitHub. So the adoption of open source is accelerating. It's becoming commonplace. It's no longer an esoteric area. It's actually very rare that you would encounter any software projects today that don't include at least some open source components. The open source is typically directed towards features that are more commoditized. And like Rock was mentioning earlier, this might be open source. The basic features of a software program might be open sourced, and then you might keep some of the more advanced or complicated features proprietary and build on top of that open source to give yourself a competitive advantage. So there are open source projects directed to lots of cutting edge technologies today, not just blockchain, cloud, AI, and other projects. But since this is a blockchain focused webinar, it's worth mentioning that Hyperledger is an open source project now governed by the Linux Foundation, which is a free open source platform that offers a lot of tools and frameworks for developers to create enterprise focused blockchain solutions. I did a search for the keyword blockchain on GitHub, and it came up with about 100,000 repository results. Most of these are forks from either Hyperledger or Ethereum or other popular blockchain platforms, but there is a lot of activity there. And, you know, open source has changed. For example, back in, I don't remember what year, I think it was like 2001, Steve Ballmer, who was CEO of Microsoft, said that Linux is a cancer and that no intellectual property can be protected with open source. And then Microsoft open sourced their .NET platform in 2014. And then they bought GitHub in 2018. So things have completely turned around. And the main reason for that is that no one company can effectively compete with the open source ecosystem. And that's basically it for that.
Why is that? Why do you say that no company can compete?
Because the advances that are happening in open source are like Linux. The Linux operating system is updated about 9 times an hour on average. There's not a company with enough resources to be able to keep up with that pace, because there are people all over the world with different interests advancing the different open source projects. The pace is not sustainable within a company.
Interesting. So maybe Rock, if I can go back to you, can you maybe speak to the type of licenses that exist in relation to open source? Maybe you can go through the slides.
Sure, yeah. So as the slide says, at a high level, there are really two kinds of licenses. You have permissive licenses and you have restrictive, also known as copyleft licenses. So if we could advance to the next slide. The permissive licenses are, as you think they would be, they allow you or they permit you to freely amend, adapt, combine, basically do what you want with the open source code, even integrate it with your proprietary code and create a commercial product. A lot of times, the requirements are pretty straightforward. So they usually only require that any distribution of the originally open source software be on the same open source terms that it was received in. So what you'll see a lot of times, for example, if you have a permissive license, you go onto your phone, you go into the about field and you see the open source disclaimer, which has all the various kinds of licenses that are there. And you'll see that one of the requirements is that it says we're using this piece of open source software. Here's the very short permissive license that says we're basically allowed to do whatever we want with it, subject to, of course, making it known that we're using the software and including this attribution notice in the product. So you've got a lot of freedom. You've got to provide notice, you've got to provide attribution, but they are designed to be compatible with a proprietary license. And that's in contrast to the other kind of license I mentioned, the restrictive or copyleft licenses. Those tend to be the general public license, the GPL, which is a very popular kind of open source license, which we'll talk about more, or variants of it. And there, the biggest restriction is that if you, using the GPL again as an example, if you create a derivative work on the GPL, so for example, if you take the piece of open source code that you have that is GPL licensed and you modify that and you want to keep your modifications proprietary, but at the same time, you want to be able to distribute copies of your software to your customers, you're not going to be able to do that. The GPL says if you modify that piece of open source software and you distribute that software to your customers, you've got to make your own modifications public. You have to be able to let your customers download that source code, which of course is a problem if your business model is predicated on keeping that source code secret. I'll mention here as well that the GPL, a lot of these licenses, the GPL as well, they're quite old. So they were created at a time when software commercialization business models were different. It used to be that everybody distributed their software. But of course, that's not necessarily the case anymore. You have a lot of web services now. Software as a service is a huge business model. And the GPL actually doesn't cover situations where you're not distributing the software. So if you've got open source software that you're using entirely internally, and you're making the functionality available to people outside your organization, like your customers, the GPL won't require you to distribute that software, but a separate class of licenses, the most prominent of which is called the AGPL, will. So you've got licenses which are restrictive, which require you to make available source code that is derived from or combined with code that is licensed under the GPL. And that requirement can kick in when you distribute the software in a conventional, I'll call it, business model under the GPL, but it can also kick in under a newer class of licenses like the AGPL if you're just making that functionality available online.
Okay. I think we have another slide.
Yeah, if we could go to the next slide, there is a example list of licenses here, and we can go through them fairly quickly. Some
technical difficulties. So just while we're waiting for that slide to come up, Leslie, did you have anything to add to the licenses at all, or?
Yeah, so I just wanted to mention one thing. So like Rock mentioned, sometimes it's impossible to comply with the GPL because you don't want to disclose your own proprietary source code. And permissive licenses are very easy to comply with. Basically, most of them just require you to redistribute the license and provide notice, reproduce the copyright statements. But you do still have to comply with them. And where a lot of companies get in trouble is they say, oh, it's a permissive license, I can use it for wherever I want, great, I'm using it, that's it. If you don't provide those notices, which is easy to do, but if you don't provide those notices, you're not in compliance with the license. And that has tripped some people up because if you're not in compliance with the license, you could actually be held to not have a contract at all. And then you bring up the specter of copyright infringement. Or even if it doesn't go into a legal dispute, the reputational damage is hard to quantify because people don't want to be seen as bad actors in the open source community. That kind of reputation will follow a person or a company around if you disregard or disrespect, and as some people call it, intellectual property rights.
Okay. While we're just waiting for the slides to come back on, so Rock, if I can maybe push forward on the question. So what are some of the risks when using open source software? And perhaps if you can also just speak to the best practices, and then I'll turn to Leslie and others and Fiona as well on that point.
Sure. Well, I think the biggest risk is with the restrictive licenses, where if you have a code that is proprietary and you are wanting to keep it secret, and you inadvertently get it licensed under a restrictive license like the GPL. So you modify GPL licensed code, and without wanting your proprietary code to be governed by the GPL, it is, and that arises, for example, in litigation or in due diligence or something like that. So it's the inadvertent requirement to make your source code publicly available. One thing I'll note here is that we've talked about the permissive licenses. We've talked about two kinds of restrictive licenses, the GPL and the AGPL. I'll add a third GPL variant, which is also very common. It's called the LGPL, the lesser GPL, and that is used in particular for libraries. So the position of the people who have authored the GPL is that if you have a software library, which is basically a software module that is used to implement a certain type of functionality, and you want to distribute that under the GPL, the position of the Free Software Foundation, which are the people who wrote the license, is that regardless of how you integrate that library's functionality with your main body of code, that's called linking. You can link either before you distribute, which is called static linking, or you can link after you distribute, which is called dynamic linking. Their position is regardless of how you link, if you do that linking, your entire code base that links with the GPL code is governed by the GPL, which I think they found is a disincentive to using the GPL in a lot of situations. So the LGPL is a license that actually permits you to license the library just under GPL terms. So if you modify the library, then you've got to make your modifications to the library publicly available, but you can link to that LGPL licensed library without having to make your entire code base publicly available. So I do want to mention that third kind of license because it is a restrictive license, as we show on the slide, but it is a restrictive license that I think is fairly widely used because it can be used in a way that makes commercial sense for a lot of clients.
Okay, so we have the list of licenses up. So I think our slides are now back up and running. So maybe if we move to the next slide, to slide 11, this was really the risks that you were talking about. Rock, I don't know if you wanted to speak to any other part of that before moving on to the best practices.
Sure. I mean, I think Leslie's mentioned a couple of these. I have as well. The biggest one in my view is that second one, allowing competitors to gain access to proprietary source code, which I just talked about. As Leslie mentioned, another big one is reputational damage and business continuity issues. She's also mentioned contract and copyright infringement, because even if it's very easy to comply with a license, easy doesn't mean you don't have to comply. It means you still have to comply. And if you don't, even if it's a permissive license, you could end up in a place where you're liable for breach of contract or copyright infringement, which again, as Fiona will talk about, can be problematic, particularly during an M&A context. And all of this, of course, goes to the customer, goes to the client. It can all be prejudicial to new customer relationships because you never want to go to a customer and say, the product that we have given you is not what we thought it was. That's a bad story.
Right. Okay, we're going to come to M&A in a second, but Leslie, I don't know if you had anything to add further on those points.
Just one point. So a lot of this stuff, like Rod mentioned, it's easy to comply with some of the license, and you want to do your analysis before you release the software. But what trips up a lot of companies is that your initial analysis says, oh, I'm just going to use this piece of LGPL code internally. We're not going to put this in a product. It's fine. So they start using it. And then they find a use for it in a product. And since it's already been approved and in use in the company, the developers think it's fine to use. So the use case is extremely important to whether or not a piece of code under a particular license is a good idea or not. And so one thing for companies to keep in mind when you're implementing an open source policy and your procedures is that just because a piece of code is okay for one scenario does not mean that it's okay for every scenario. And the analysis needs to be done on a very use case specific basis.
Okay. So Rock, you had mentioned M&As, so let's discuss M&A transactions. And I'm going to pick on Fiona a little bit here as our transactional lawyer. How do open source issues affect or play into an M&A transaction?
Thanks, Usman. M&A transactions have a lot of different components and pieces to them. And one of the things I find when issues pop up, one of the things that happens is there's significant delay. And with open source issues are fairly complicated. And more often than not, they may pop up on a disclosure schedule. You may be made aware of them during the due diligence phase. And so during the diligence phase, there's all these requests for information that go to the target company. Often with open source, and this is, maybe not large companies like Leslie's SAP because they know what they're doing, but have a lot of experience in that. But a lot of companies who haven't gone through the M&A process, they get these requests, and now is when they have to go talk to, the CTO or a developer to figure out, do we use open source? How do we use it? When do we use it? And so the information that comes back to a buyer in many cases is information that they see and it's incomplete, or it's not listing specific versions, as Rock showed on the previous screen. There's different versions of the same type of open source have different implications. And
Right.
So often when that information is not forthcoming, it causes a delay. And I can say I've seen a number of transactions over my years of practice where something has come up in the diligence process. It's led the buyer to say, we're not comfortable, we don't know, or they don't know exactly what they're using or how they're using it. So even though our target date was X, we now need to slow down and figure this out because it could have, as Rock indicated, significant implications, whether it's allowing competitors to gain access to proprietary code or otherwise. And so, significant delay in signing or closing are one of the big issues that we face. As well, I found that when issues like this pop up, the buyer tends to slow down not just on these issues, but sort of slow down and take look more closely under the sheets on a number of other issues. Because if they found one, they're concerned that there may be others. And so that leads to significant delay among the parties. And it also changes in many cases the deal economics or how you balance liability on a transaction. So when an issue, I can think of a few deals where we had issues with open source that came up. And so now instead of focusing sort of on the transaction and moving that along, we sort of pens down on the transaction and had to work through what is the cost to fix the issue? Is the issue fixable at all? How long is that going to take? And so, and then what does that mean for how they price the deal as a buyer? They're also trying to look at, is there past non-compliance? Are there compliance issues that have already, or lack of compliance that's occurred due to how they're using open source? And so all of those issues, liability and changing deal economics, those are big deals. Those are big items. And then as well, when you put all those together, buyers saying, what else don't I know? And depending on how significant or how the open source has been used in a company's product or technology, in some cases, it could kill the deal, either because the buyer doesn't want to take the time to review it, do a deep dive, try to estimate cost and remediation. And as such, the uncertainty is enough for him to say, or for the buyer to say, you know what, we're just going to move on we don't want to take the risk. It depends on the risk profile of the buyer and how badly they want the transaction. But we've also seen that happen when we look at open source and how a target has used it.
So what then are some of the ways in M&A transactions to address issues relating to open source that you might recommend? So
there's a number of different ways that you can address open source issues. When I note representations and warranties, that's less a fix or an issue, but it's about understanding if I know in diligence that there is a concern, potentially a risk, I'm going to take a closer look as a buyer and make sure I provide more detailed representations and warranties and ask for more detailed scheduling of open source, how it's used, what versions, how it's incorporated, very detailed information that I'm going to be looking to call out in order to understand specifically my risk. And then once you see all that information, you then have to assess what all that information is telling you. And then in a number of cases, it results in remediation covenants. So either if you're signing the transaction now, in some cases, those covenants are pre-closing and conditions prior to closing. You may extend the period between signing a transaction and closing a transaction. And as a buyer, you say, if we can't remediate all of these items, we're not required to close at that later date that's been determined. I have seen a transaction where that remediation process took double the time which I mean, and Leslie will speak to this a little bit later, but took way more time than anyone ever anticipated, right? In terms of actually fixing it. The people doing the transaction often underestimate the actual time it takes, for the business itself to fix some of these issues or try to address the issues the open source has caused. And so, we do put in conditions about specific items that need to be fixed, when they need to be fixed, how they need to be fixed, and a time period. As well, we've addressed it with specific indemnity, meaning that the sellers will have to make buyer whole to the extent there's claims, et cetera, related to a breach of open source, or there is, a competitor has been provided access to proprietary code, and that risk, we have an indemnity for that. That being said, I will say that, an indemnity is only as good as, you can put it in writing and you can put it in agreement, but you have to know that that's a solid indemnity and you have the ability to collect on it. So you also have to sort of examine the deal structure, who the sellers are, and so there's a lot of time spent reworking and adding in the specific indemnity so that you know that you can collect. And usually, and in many cases, that indemnity is backed up by an escrow. And an escrow is a money that's not paid on closing. So if you had a deal where you were going to pay X% of the purchase price up front, and 1 year out you were going to pay another percentage, or you had or after 60 days, 90 days, that you would pay another amount, or there's an adjustment process, this escrow would be held for a certain period of time, and usually a longer period of time, to make sure that remediation is possible, to make sure that there's no loss of valuable IP rights, that a competitor isn't out there using proprietary source code. And so that adds risk for the sellers, and it gives the buyer some protection, but the time that the buyer has had to take to decide if that's an appropriate fix is usually requires them to have gone in and done a pretty deep audit of the code, et cetera, and the licenses that are being used.
Okay, and I'd appreciate perhaps all panelists comment on this, but we'll start with you. From a deal perspective, how can a company, what are some best practices that they should have on the front end to address some of these issues that you've identified relating to open source?
The best process is to, I mean, Rock's outlined a little bit of it already, but if you're going to use open source, you need to have a policy, whether it's part of your IP policy or whether it's part a specific open source policy, where you understand as an organization, do you need specific approvals for use of open source? Who has the ability to approve that? Is it your CTO, or is it the CEO, or is it the board? Who gets to decide how open source is being used, when it's being used? It's also a process, and a specific process that's laid out for your IP team about recordal of licensed versions, making sure you know when it's used, that it's been approved, that you know the version you're using. And I'm going to tell you, as a buyer, when you're looking at when you're dealing with a transaction, that might be something that when you ask for that in diligence, it says a lot about an organization and the process and the legal process they have in place and the governance. If when you ask, do you use open source, that's great, but can you show me your IP policy or your open source policy, and the company doesn't have one, sometimes that's telling for a buyer in terms of what additional work and investigation should they be doing to get some comfort level. I can think about a transaction I did a couple of years ago where we did have an open source issue. Open source was used. Top management didn't know what open source was used, who was using it. There was no process or protocol in terms of how it was done. And it was pretty significant in terms of trying to determine that and go back and try to sort through it, and then also try to dig up old, open source licenses and trying to figure out which versions were used. And it was timely, and it ended up being costly. So the other thing is periodic, scans, audits, and these are things that whether or not you're gearing up for M&A, it's easier done if it's just done as part of your regular process. And then when and if you do an M&A transaction, you've already got all this ready and in place. I would also suggest that, ensure that your contract contain provisions to provide appropriate protection. So if you're licensing from other parties, different inbound, understand what it is they're using and have appropriate protection to protect you in the event that they've included open source and now you're using that as well. And then I would say, to the extent there are red flags, problems, I always say to people, address them now. Don't wait for an M&A transaction, but also if they come out as you're preparing for an M&A transaction, address them. And you also have to be transparent about it, because it's these things can go to the heart of a transaction. And if you don't sort of address them up front or understand what you have, as I said earlier, they tend to kill deals.
Okay.
And I know Leslie, I was going to say, I know Leslie probably has some stories or thoughts to add on this. Absolutely.
I agree with everything you just said, Fiona, and just a couple of additional things. The due diligence question, which is always asked, what open source do you use? If the company being acquired, because I'm on the buyer side, if the company being acquired comes back with the answer, oh, we don't use any open source, that is a huge red flag, and which means you're going to be investigated very deeply, because it kind of indicates that you don't know what's happening in your development. And the importance of scanning. So we use Black Duck internally. I think a lot of big companies do, maybe even some small companies today, but Black Duck, and there are others out there. I think there's actually some open source products that scan for open source components that will tell you what you have. And being prepared and having a good answer to the question of what open source are you using will do a lot to advance the deal. And the other thing is, it's not just in the context of M&A. We get this question from customers. Customers are starting to become more interested in what open source we are using for a variety of reasons. They don't want to have their own code that may run on top of our code be infected. So it's kind of in the supply chain. You want to check the code that you're using on the inbound basis. And then if you're supplying a product that others will build on top of, they're going to check you out. And it also is back to the community. There are a lot of open source enthusiasts out there who really want to see compliance with licenses and think that the notices are very important, and they will do investigations on their own to find out whether or not someone is using their code and not providing the appropriate attributions.
Okay. Rock, anything from you, or should we push on?
Yeah, a couple points. I think just to echo and sort of delve or add to what Leslie and Fiona said, which I agree with completely. So yeah, I think an open source policy is important. I think it's important that it be practical and realistic, because like you may have a policy that says just don't use open source, and then maybe in a deal you say we don't use any open source, but I'll bet you have open source. that someone who had to one of the coders who was against a deadline and knew the solution was out there and thought everything was fine, just unilaterally sort of made the decision to download that software and incorporate it in your product because they didn't think the policy was realistic and practical. So I think it's a situation where you want a workable and practical policy so that you can manage that risk and reap the benefits and maintain your credibility in a transaction. So I really do think in this field, credibility is really, really important. Like Leslie just mentioned, there is a very fervent community, open source community. And a lot of times there is disagreement between what the open source community thinks the open source licenses say and what I would respectfully submit as a lawyer, the open source licenses actually say. And there's not a ton of litigation with published decisions in the area where you can point to black letter law and say, I'm right or you're right, or I'm wrong and you're wrong, or you're wrong, because a lot of these cases, when they do arise, they settle. So you don't get that guidance. So if you don't have the guidance and you have maybe a disagreement between what someone in the community says and what you're saying in a deal, credibility is key. So I think you really do want to stay on top of things and, of course, maintain your credibility throughout the transaction. I mean, for a ton of reasons, but this is one of the reasons. And for best practices, the only other thing I'll add is I think it's a best practice to keep the open source software you use in its own directory or repository and just link to it. If you have a permissive license and you're complying with the license, providing attribution, legally, you wouldn't have to link to it. You could copy and paste the code and put it in your code base. But I just don't think it's a best practice, because if something goes wrong, if you make a mistake, you're going to be in a better position if you've got a completely modularized piece of software where the open source software is not literally copy and pasting your code. You've linked to it. You can maybe replace it with a different piece of modular code. You might have an argument that by virtue of the linking that you haven't arrived at a place where you're governed by the open source license. You've just got a better backup position.
An easier remediation for sure.
Yeah.
Yeah, for sure. Yeah.
So we now know what open source is. We have discussed how it affects transactions. I wanted to focus on how to manage open source once the deal is done. And Leslie, in particular, I appreciate your thoughts on this. From your perspective, what should a company do to mitigate the risks associated with using open source code, and how can it put itself in a better position for due diligence?
So we've talked about a lot of this already, so I'll go through it rather quickly because I know that we want to leave a little bit of time for questions at the end. But a policy is important. The policy should include enough detail to allow employees who are following the policy to know what they can and cannot do. It should have management buy-in so that it can be enforced if needed. It should be clear so that others in the context of a transaction can understand what the company is doing with open source. And in addition to employees, it should be understood and followed by third-party software suppliers, the inbound thing that Rock mentioned a few minutes ago, service providers, contractors, others who will be touching the code. And it should have training in a perfect world. Training is a good practice because it allows the employees to understand the risk associated with using open source and their obligations. And it allows employees to identify the key issues in open source licenses. Another important component of the policy is that it should identify the personnel responsible for managing open source within the company. At SAP, this is done by what we call the Open Source Program Office, which is something that is starting to get more traction. A lot of companies are starting to have an entire open source program office rather than just one person who's responsible for it. But at a smaller company, it might make sense for the chief technical officer or some other designated individual to have responsibility for open source. So at SAP, the OSPO office is about, I think, 10 people, and they're responsible for everything within that touches open source. That's internal, how we use it, how we contribute it to other projects, how we talk about it in the public in our community relationships. So one of the big things in our policy is how we contribute to open source projects, which brings up a topic I wanted to talk about a little bit, which is why would anyone contribute to open source projects? You're just giving away your IP, right? Can you go to the next slide? There are actually a number of reasons why a company might want to participate in these projects and contribute code. It's really a donation of code because you're giving it to them for free. I think we've mentioned many of these before. It is really good for encouraging wide adoption of technology. If you get a platform out there and you want to get platform adoption or create a de facto standard for a large user base, this is probably the reasoning behind a lot of the blockchain projects. At SAP, we do it a lot because we want to collaborate with our customers and partners. There's a lot of software that interacts with our software. And in order to create those integrations, we make some of our code available under open source projects so that customers and partners can develop these integrations and integrate SAP software with other software. Obviously, it can build goodwill and reputation within the open source community. And one thing that hasn't been mentioned yet, but is actually a pretty big reason to participate is that almost said kids, it's not kids, young developers coming out of universities are very active in the open source community. If you want to attract and retain this talent, being active in the open source community can really help you attract and retain this talent. For your existing employees, it can facilitate improving development skills for those who participate in open source communities. Being able to show that you are an active participant in open source communities can go a long way. If you can go to the next slide. I just want to say a few words about what SAP is doing, just kind of promote our open source activities, and also say a few words about how this can be applicable anywhere. So one part of our strategy is to support the technology that we rely upon. These are all projects that we use internally, either in our products or for internal development processes. One thing we do, and I would encourage anyone to do, is to contribute any bug fixes upstream. This is a best practice, not only because it's good community behavior, but if you don't do this, it could if you don't do this, you could be considered a free rider, which would be a bad reputation. But if you do fix the bugs in the project, it actually helps yourself because you will have access to that contribution, that bug fix in the future. If you don't contribute it back to the community, next time you download and update a version, you'll just have to fix that bug again. So once you fix it upstream, you don't have to deal with that bug again, and everyone benefits. As I mentioned earlier, Linux Foundation governs Hyperledger. Hyperledger is an umbrella project that includes several sub-projects such as Hyperledger Fabric and others. The other reason to contribute to these projects is that we want to influence the direction. If we think that certain functionality needs to be developed by the community, by being an active participant and actually contributing code, we can better influence the direction the projects are taken. So if you contribute the time, you can dictate the future of a project in many cases. If you can move to the next slide.
Well, just on that last, so Leslie, it appeared to me, because our logo was there, that I thought that you were using our code or something from our firm.
Don't know how that logo got on there.
Go ahead.
So SAP also created our own projects. Not only do we contribute to the Linux Foundation and other projects, but we have created our own. Some of these are to influence or get adoption of SAP products, like the OpenUI 5 project is used to integrate with SAP products. Some of them are more just general security research. We've created some projects that are just directed towards cybersecurity issues in general, not really directed to an SAP product. And then if you move to the next slide, just a few final words about what do we think about? You know, we don't just allow employees to go out and start contributing whatever they want, because you would soon have your proprietary code out in the open source community. We actually have an approval process so that development teams or even individual employees, when they want to make contributions, they go through the process. In general, if it's a bug fix in an upstream project, that's approved. You know, that's just kind of standard practice. But in other cases, we look at some different factors that are shown here. First, we sometimes have to consider whether or not we have the sufficient IP ownership to actually donate the code. We have to make sure that it was written by SAP employees, or if it's written by a contractor, that we have the rights to license it out in this way. In those cases, we might have to check the agreement with the contractor to assure that they have given us sufficient IP rights to do this kind of license. As Rock mentioned earlier, we want to make sure that there is no unintentional disclosure of confidential information. This frequently comes up in terms of proprietary APIs. If we want to keep an API proprietary, we take special care not to release code that might disclose what the API is. If it's an open API, that's really not an issue. There are a couple other issues which are really beyond the scope of today's talk, but you know, some of the all the open source licenses will grant a patent license. Some of them make it explicit. And so we have to consider the impact on the patent portfolio, which could be a whole hour in and of itself. There could be export control obligations if the code contains encryption. We want to make sure that we're putting the code, if we put it on a third party's website, that it is a repository that doesn't violate any of our internal development standards. And that is basically it for contributing. In terms of other best practices, we do a lot of training, and the training can be directed towards developer, a deep dive into our processes. And then we also have some more higher level training, which is just for product people or support people, just so that they are aware of SAP's involvement in the community and what open source is at a higher level. So I think training is an important component if you have the resources for it. And then otherwise, you know, it's back to the policy and the procedures on how to manage open source.
Okay, that's terrific. I've asked everyone if they have questions that they'd like to ask any of the panelists. Feel free to use the Q&A function. I saw that we had one popped up, but that's been answered. So feel free to use that function. And I'll just see if there's any right now. Maybe just while we're waiting for any final questions, Rock, Fiona, any comments on that, or maybe any other thoughts on where the future is headed with open source and IP rights, or other best practices that you wanted to share?
I will echo what Leslie said in terms of recruitment and talent. I mean, particularly in this labor market. I hear time and time again from clients about well, of course, the importance, but also how difficult it is to recruit top tier talent right now and how competitive it is. And being able to give back via open source, and maybe even more generally along the same line, publishing results of research, which isn't open source in code, but a different kind of open source, really. That kind of policy and procedure where you can give back and help your employees and coders increase their credibility, that can be a really important piece for talent acquisition and retention.
Okay, that's a good point. Go ahead, Fiona.
Yeah, and I would say the same. The collaboration is, and sort of the feeling of that innovation and collaboration is sort of key right now. To Rock's point, for recruitment and to keep people motivated. The other piece I would say is what goes along with that, and I would really echo Leslie's point about the training, right? So policies are fantastic, and setting processes are fantastic, but it's about training and consistent training as well in terms of how do you do this and what do we expect? And I think as an organization, a lot of organizations implement policy without the training to go along with them, or there's the view, that there's a database somewhere that all the policies are listed, but no one actually ever reads or reviews them. And so I think that training and process sort of on a continual basis, I think that's critical, and it'll help prevent errors that, in many cases, to Rock's point about, hey, I'm rushed on a project, I have to download something. And there's a policy maybe, but I haven't looked at it. I think a lot of the unknown and errors with open source come just from a lack of understanding about the implications and the risk profile and the risks that the organization are trying to prevent against.
Okay, two questions that have popped up, which one is a simple one, and then one I'll turn to the panelists. The first question that has come up a few times is, will this package of materials be made available afterwards? Yes, it will. We will be sending it out. So thanks for that question. The second question is from one of the attendees or the audience members who says, how common is it that OSS licenses also restrict users from protecting their OSS solution with other forms of IP rights, which would still enable them to comply with an open source code? I'm not sure who would like to handle that, Rock. Maybe I could turn it over to you.
Sure. So there are three IP rights that can apply to software. Copyright, which prevents copying generally. You can also keep it confidential. So that's if you want to keep your software trade secret. And then, as Leslie mentioned earlier, you can also patent software sometimes. So if you're going to open source your software, trade secret is irrelevant. You're not going to keep it secret. The only other right would be the patent right. And I think, as Leslie mentioned, either implicitly or explicitly, when you're open sourcing your software, you're giving people a license to use that software, including if it's covered by a patent. So it's not so much, I think, that an OSS license would prevent you from patenting certain functionality necessarily, but it could very well prevent you. I think it would prevent you from enforcing that patent against someone who has licensed the software from you under an OSS license. Leslie, I don't know if you want to add anything to that.
Yeah, so I mean, if you think about it, it wouldn't really make sense if a company could make their code available under an open source license and then sue later over patent infringement for using that code. So yeah. There's almost, I think it's pretty settled that there is an implied license. What is not settled is the scope of that license. So while you may have a patent on a particular set of functionality, there may be multiple ways to implement that functionality. And the scope of the patent license provided by the open source license has never been litigated as far as I know. And it's just one of those you just have to kind of think about it in terms of what is fair. I mean, if a company makes some code open source, I don't think they could later sue for patent infringement for someone using that code. They could sue someone for patent infringement if someone developed code on their own that implemented the patented, the claimed functionality, but I don't know if that has actually happened yet or not. Rock,
Yeah.
have you seen any litigation in this area?
In this, for this particular issue, no.
No. Yeah,
I mean, the
yeah.
other reason you might want a patent is if there's a breach of your license and you want to enforce,
Yeah.
then you could do it too. So I think the short answer is, which Leslie put more elegantly than me, yeah, you can maybe protect your software in various IP rights, but if someone's validly licensing it under the OSS license, don't count on enforcing any of those other rights.
Yeah. So you still have a patent. That patent is still valid. It just
Yeah.
may not be enforceable as much as you would like it to be.
Okay, well, excellent question, Lisa. Thanks, Rock and Leslie, for those answers. We're now at the hour. We're just a few minutes over, so why don't we end things there? I want to thank all of you in the audience for joining. It was a fascinating discussion. I want to thank our speakers, Rock, Fiona, thank you so much. Special thank you to Leslie for joining us on our panel here today. I want to remind everyone that we're having our final session in this webinar series on October 14th on blockchain litigation. We hope to see you there and have a terrific rest of your day. Thanks a lot.
Thank you.
Thank you.
Thank you.
Bye.